Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of us who live in civilian disarmament states, we know this. For the rest of you, you're going to have to take our word for it. But they will try to attack your Second Amendment rights any way humanly imaginable. And one of the ways they like to do that is to attack the FFL industry, to try to drive every single gun store completely out of business in that particular state. The state that's the king of it, of course, is California, and then my state, Washington, recently decided to play copycat with them. What we're going to talk about today is an immensely important lawsuit, because it's an immensely important lawsuit because, well, as you know, this type of craziness could come to your doorstep someday soon as well. So today, let's spend a few minutes and let's talk about the case to save the FFL industry. Okay, America, here's what we're talking about. There is a statute in California, and now there is an exact replica of it in Washington State that requires all FFLs to have 24-hour, 7-day-a-week video surveillance of all areas in which a transaction may take place, to store that data for a number of years, and then, of course, make it all available to law enforcement upon request. It is literally a place where a person completely waives all sorts of constitutional rights. And, of course, in these states, you're also waiving medical privileges and things like that because you have the audacity to want to buy a gun. Now, it would seem that there would be a lot of constitutional issues with that. There is, and we're going to be talking about all of those today in the case of Richards v. Newsom. Now, this is a challenge to a California statute that went into effect about 3 years ago, but Washington, you need to pay attention here, okay, because House Bill 2118, which now goes into effect July 1st in Washington State, is an exact replica. And so these challenges being made by all of these following organizations: Gun Owners of America, Gun Owners Foundation, Gun Owners of California, the California Rifle and Pistol Association, and the Second Amendment Foundation. Yeah, Washington, you need to pay attention to the challenges they're making here because they would be equally applicable in Washington State. Why? Well, because word for word, it's the same damn statute. So this case is before the Ninth Circuit Court of Appeals. I know all of you are rolling your eyes already. I get that, but for you to understand just how important the issues are, they are outlined as follows. 1. Does a warrantless government mandate that firearm dealers collect audiovisual recordings of people engaged in constitutionally protected activity at all hours of every day and store and maintain that data for government inspection on demand constitute an unreasonable search in violation of the Fourth Amendment? Okay, so we got a challenge under the Fourth Amendment, but there's more. 2. Does a law that compels a firearm dealer to install, operate, and maintain surveillance infrastructure for the government's exclusive benefit at a substantial expense and appropriates private property for continuous data collection without compensation constitute an unlawful taking under the Fifth Amendment? There you go. Fifth Amendment challenge. But guess what? There's even more. 3. Does a law requiring a firearms dealer to continuously record audiovisual surveillance of their premises, including conversations in private homes, violate the First Amendment by chilling protected speech, deterring political association, and eliminating anonymity in expressive activity? Yeah, and you may notice the term "in a person's home." What does that got to do with it? Oh yeah, you thought that this law exempted home-based FFLs? Oh, of course it doesn't. No. So in California and Washington right now, you actually have applicable law that mandates 24-hour, 7-day-a-week, 365-day-a-year video surveillance inside a person's home simply for the profession that they've chosen. Sounds pretty crazy, but as the plaintiffs point out here, the lower court in California had no problem with it. The court reasoned that not even those forced to install cameras inside their own homes and perpetually operate them on behalf of the state, all at their own cost, can so much as state a claim upon which relief can be granted. Yeah, that's right. The lower court had actually thrown this lawsuit out on its ass, so you don't even have a claim here, okay? In fact, the lower court had also stated, rejecting plaintiffs' Fourth Amendment claims, the district court observed that commercial firearm dealing had been recognized as a closely regulated industry where no reasonable expectation of privacy could exist for a proprietor over the stock of such an enterprise. That's right. The court actually ruled that you have no expectation of privacy, even inside your own home, because of the profession that you have chosen. Now, as we mentioned earlier, the plaintiffs here are raising three separate constitutional challenges, okay? The first one falls under the Fourth Amendment, the prohibition against unreasonable governmental searches and seizures. The plaintiffs point the issue out this way. First, it amounts to a trespassory intrusion on private property. The state forces citizens to install surveillance equipment that continuously records images and conversations inside constitutionally protected spaces for the government's exclusive benefit. The state did not contest this point below, and the district court bypassed it entirely, skipping straight to whether the use of the footage was lawful while ignoring the threshold question whether the state compelled creation of those recordings is itself a Fourth Amendment search that requires a warrant. It is. That's right, because you need to understand, it's the moment that the data is collected at the government's bequest, no, actually at the government's order, that the search occurs. The fact that government then later reviews that data, well, that's obvious, okay? But that's through the collected data coming from what? That's right, the search. Second, Section 26806 also violates the Fourth Amendment by intruding on activities inside the home, where individuals harbor a reasonable expectation of privacy. For kitchen table FFLs, the statute mandates constant surveillance inside private residences, capturing not just firearm transactions, but also private conversations, family life, and visits from individuals uninvolved in any regulated activity. That level of intrusion is not justified by the presence of a business license. And of course, is this really private, sensitive information? Well, the plaintiffs do a fantastic job of saying, well, you know, the statute kind of says that it really can't be shared with anybody at all except for government, which means it must really, really be private, as they put it. Even the statute implicitly concedes that the data collected is constitutionally sensitive. Section 26806B forbids the conscripted license to use, share, allow, access, or otherwise release recordings except one, to a government agent conducting an inspection of the licensee's premises to ensure compliance with the law, but only if a warrant or court order would not generally be required for that access, or two, pursuant to a search warrant or other court order, or three, in response to an insurance claim or as part of a civil discovery process. So, as you can see, a very solid Fourth Amendment argument. But there's more, right? Because now there is a Fifth Amendment argument under what's called the unconstitutional takings. That is when government deprives you of property without just compensation. The plaintiffs here outline the issue as follows. The takings clause of the Fifth Amendment provides that private property should not be taken for public use without just compensation. That protection applies equally to the states. Section 26806 mandates exactly such a taking. It requires firearm dealers, including those operating from their homes, to install, maintain, and operate continuous surveillance systems on their private property. These systems must meet government specifications and serve the state's investigatory interest exclusively. Dealers are barred from using the footage for their own purpose and must bear the substantial cost of compliance. This constitutes both a per se physical taking and a regulatory taking for which compensation is constitutionally required. And listen, up here in Washington State, as the law is about 1 month away from going into effect, I can assure you right now that I know numerous FFLs that have spent thousands and thousands of dollars retrofitting their building and their security systems to become compliant with Washington's law, which again is a carbon copy of the crap that's going on in California. Okay, so we got a Fourth Amendment challenge, we got a Fifth Amendment challenge, and now we also have a First Amendment challenge, okay? And this is how the plaintiffs outline that argument. Section 26806's perpetual audiovisual surveillance mandate infringes each of these protected rights. By compelling firearms dealers to conduct perpetual audiovisual surveillance of constitutionally protected activity and store that data for government use, the challenged law imposes a regime that chills expression, deters political association, and obstructs participation in public discourse, especially among those who dissent from California's view on gun rights. Yes, because none of us are fans of California's views on gun rights, which is essentially citizens don't have gun rights. But for those of you who have hung out at gun stores, you will know that there is a lot of political discussion that occurs. And we are in an area where we theoretically have the comfort level to have that discussion. But yeah, once you tell everybody, because you remember this law requires there's big old signs telling everyone you're being video and audio recorded, that chills expression, okay? As the plaintiffs put it, Section 26806 requires firearm dealers, many of whom are also political advocates and members of advocacy organizations, to record all in-store conversations, including those that occur at events, meetings, or informal gatherings outside of business hours and unrelated to firearm sales. The statute also applies to home-based firearm dealers without limitation, meaning that its surveillance records extends into private residences where politically charged conversations and other expressive conduct certainly occur. Okay, now, America, I know when I talk about a California law, if you're living in a state right now that's letting you live free like an American, you sit there and go, well, I get it. They're crazy in California, and that sucks for Bill up in Washington because they're crazy up there also. And that is true. How could any of this ever come to a state like Arkansas, Louisiana, Texas, or any other state that lets its citizens live like Americans? It's real simple. All you need is another terrible ATF, you see, because all it takes is for this to somehow or another get written into some kind of new engaged in the business rule or something like that. And oh, sure, there'll be constitutional challenges and APA challenges and all that, and we can duke it out in the court system. But in the meantime, what it will do is it will absolutely choke to death large segments of the FFL industry. And that is why this case right here is one of the most important cases to ever come along for the future of the FFL industry. Okay, the case once again is Richards v. Newsom. We're going to link up the appellant's opening brief down below so you can geek out on it for yourself. We're going to link up all of the fantastic organizations that are spearheading this down below so you can show them some love. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video, click on that link, tell us all about it, subscribe to the monthly newsletter. That information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.